Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. Today, as part of our trial skills series, I'm going to go more in depth on how to conduct cross-examination, in particular when you are representing yourself. So what we're going to do is we're going to start by going over some trial procedure. And first, we're going to look at trial procedure from the angle of you are the one that filed the petition or the motion that's proceeded to a hearing. So if you have a divorce case or a child custody case, the petitioner will be the petitioner at the trial. But you could be the petitioner in your child custody case, but the other side, the respondent, could file a motion for temporary order and they would be the petitioning party for the motion. They're still the respondent, but they were the one that filed the motion. So just looking at who's the petitioner and who's the respondent in the caption doesn't necessarily indicate who's going to go first at trial. What indicates who's going to go first is who filed the petition or the motion that is the basis of the trial or contested hearing. All right, so let's say you filed the petition for divorce and you're going to your divorce trial, or you filed the motion for temporary orders and you're going to the hearing on your motion for temporary orders. Either way, you are the hearing will start with opening statements. Each side will get to present their opening statement. And then the judge will turn to you and ask you to present your first witness because you are the petitioning party. And this would be a great time for you to testify. So you don't have to testify first. If you have another witness, you could present them, but most likely you will testify at this point. So you'd say, Judge, I'm ready to testify. The judge will have the clerk swear you in. You'll swear to tell the truth. And you'll either testify from the seat you're already in, or the judge will have you go take the witness stand and testify. And at that point, you're going to testify in direct examination. This is when you're going to tell your story and present exhibits in support of your story. At that point, you will be, once you're done with direct examination, you will be subject to cross-examination by the opposing party, or if they have an attorney, by their attorney, where they're going to ask you questions on cross. Once they're done asking you questions on cross, you will then testify on redirect. And on redirect, that's when you will get to testify about anything that came up during cross that you want to clarify or add more substance to. Once you're done testifying, you can call your next witness. Your next witness would take the stand. You would ask them questions on direct examination. The opposing party or their attorney would ask them questions on cross once you're done with direct. And then you could ask your witness questions on redirect. This same procedure will happen if you have another witness, and for any other witnesses you have. Of course, you need to be cognizant of time. You're not going to be able to call that many witnesses because your hearing is only going to be a certain amount of time. And you may only have you as a witness. You could only have one witness. But each witness, the procedure will be the same. Direct examination followed by cross-examination followed by redirect. That witness is done. Move on to the next one. Now, when the petitioning party is done presenting their witnesses, then the judge will turn to the opposing party and say, okay, now it's your turn. Who would you like to call to the stand? And if the opposing party is going to testify, that's when they'd say, I'm going to testify. They'd be put under oath, and then they would tell their story. And then this is where you would ask them questions on cross. Once you're done asking them questions on cross, they can testify on redirect. If they have a second witness, they can call their next witness. That witness testifies on direct. You can ask that question or ask that witness questions on cross. They can testify on redirect. Once the opposing party is done with their witnesses, you have the opportunity to potentially present rebuttal witnesses. In other words, you could testify again, but all rebuttal should be about rebutting anything that came up during the opposing party's case. So if something came up during their case that you didn't talk about in your case in chief, you could say, Judge, I want to take the stand again on rebuttal, and you could testify again and specifically rebutting something that came up during the other side's case. Once you're done with any rebuttal witnesses, and rebuttal witnesses are not required, but if you do present any, once you're done, then you move to closing arguments. Now, if you did not file the petition, you're the opposing party, and you're looking to draft your trial outline, then you need to draft questions for cross-examination for the other side's witnesses, and then you need to prepare to testify. You need to prepare to be subject to cross-examination when you testify, and then have direct examination questions and potentially redirect examination questions for any of your witnesses. So if you're the party that filed the petition or motion and you're drafting your trial outline, you need to prepare for direct examination. You'll need to prepare direct examination questions for any of your witnesses. And then you'll need to prepare cross-examination questions for any of the opposing party's witnesses. All right, let's look at the difference between cross-examination and direct examination. On direct examination, you're supposed to ask open-ended questions so that the person testifying can tell the story. So you would say, what is your name? You'd have them tell the story. Whereas on cross, you're essentially making a statement and then comma right, comma correct, comma isn't that true? You are trying to get the person testifying to answer yes or no. So direct examination, what is your name? The same question on cross would be, your name is Julie LeBenz, right? So if I'm the witness and they say, what is your name? My name is Julie LeBenz. On cross, your name is Julie LeBenz, right? Yes. So let's do another example. Again, direct examination is very open-ended. So let's say you're talking about there's some sort of story being told about what, okay, well, what happened next? And then what? You know, those are going to be direct examination type questions. But on cross, it's more specific. Then you kept Olivia overnight on Sunday, March 5th, 2023, didn't you? So let's say at issue, let's say it's an enforcement case and it's about the other side extending their parenting time beyond the court order. And so let's say they weren't supposed to have the child on Sunday night. So this is a good cross-examination question. You kept Olivia overnight on Sunday, March 5th, didn't you? Whereas on direct, it would be, well, what happened on Sunday, March 5th? So another example of cross-examination question. You were charged and later convicted with assault for domestic violence, correct? Versus, have you ever been charged with a crime? Have you ever been convicted of a crime? So you can see direct examination is broad. The witness is supposed to tell the story based on the broad question that's answered or asked. Whereas cross-examination is very to the point, looking to get a yes or no response. Let's look at some tips for answering questions on cross. Number one, make sure you understand the question. Ask for clarification if you don't understand the question. If the person asking the question just goes on and on and on, there's not really a question in there, don't answer. Say, I'm sorry, what's the question? If they ask two questions in one and it's confusing, I'm sorry, can you rephrase? You asked me multiple questions at once. I'm confused. If they use a word you're not familiar with, ask for clarification. It's really important to make sure you understand the question before you answer. You can answer yes, you can answer no, you can answer I don't know. The important part is to answer honestly. So, okay, we've got some questions. We'll get to those questions in a bit. Do not get into an argument with the questioner. So if you and your opposing party are both representing yourselves, sometimes things can get heated when the questions unfold. But from my point of view, it really cuts away your credibility with the judge if you're going to get into an argument with the questioner while you're on the stand. So maintain your cool, maintain your calm, maintain your professionalism, and do not get into an argument while you're testifying. Don't ask a question and response unless it is to seek clarification. So sometimes people get a little snarky and like a question will be asked and they'll be like, well, what would you do? You know, or they'll ask a question back, or you know that's not true, don't you? Or something like that. But don't do that. The judge hates it. Just the only time you'll ask a question and response is to seek clarification. Otherwise, just answer the question. Remember, you will get a chance to provide additional testimony on redirect. So if you're getting caught up in the yes and no, but there's a lot more to say, That's what redirect is for, is to say the additional stuff on redirect. So if you need to make a few notes during cross-examination so you remember what to go back to, you can do that. One other important tip is to not talk over the questioner, okay? The judge is gonna want the record to be clear. So when the person asking the question is asking the question, don't cut them off and start talking. And when you're giving your answer, the questioner shouldn't cut you off and start talking. So it's important to not talk over each other. That will definitely upset your judge if you do that repeatedly. All right, let's look at asking questions on cross-examination. If you are dealing with a divorce or a legal separation case and you're at trial or you're at a motion for temporary orders, what are some questions that you could ask? Well, how about, property and debts? What is in dispute? Okay, if one side is claiming that they have a separate property interest in a certain piece of artwork at your house, there's something on the wall and you say it was purchased during the marriage and the other side says no, they had it prior to marriage, that would be a good thing to ask some questions on cross. Isn't it true that during our marriage we bought that artwork while we were in Sedona the year after we got married, and we bought it at that gallery, right? Whatever the disputed point is, you want to start crafting some cross-examination questions, ideally to prove your point. Okay, so there's a question, what type of clarification questions? There isn't a list of them. I'm saying if you're asked a question and you don't understand what's being asked, you should seek clarification. So if someone says, for example, what are your thoughts on, or let's say they say, you were ousted from the marital home, weren't you? I'm sorry, I don't understand what you mean by the word ouster. Can you clarify? You were ousted and then you left and then you went on a picnic and then you talked to so-and-so and then you did that, right? I'm sorry, you just asked me like 5 questions at once. Can you clarify and just ask one question at a time? Thank you. Or maybe you just space out for a second and they ask a question and you weren't listening because you were thinking about your last answer. I'm sorry, can you say that one more time? I missed the question, I apologize. So that's what I mean by seeking clarification, but you only want to seek clarification if it's true. If someone's like, your name's Julie Lebenz, right? I'm not gonna be like, can you rephrase? I mean, that's just dumb. Like, answer the question if you understand, but be listening. And if they ask a question and you're totally clueless or you weren't listening for a second, seek clarification. That's what I mean by that. All right, back to this slide. So what types of questions could you ask about on cross-examination in the context of a divorce or a legal separation trial or a motion for temporary orders? So really focusing on what's in dispute regarding property and debts and crafting questions around those things that are in dispute, ideally to prove your points. Spousal maintenance. Is there an issue about do you or your spouse qualify? If so, make some questions about the qualification. The amount and duration of spousal maintenance, is that in dispute? If so, craft some questions about that. Legal decision making, what is in dispute and why? What questions can you craft about legal decision making or parenting time? Child support, do you agree with the numbers in the opposing party's child support worksheet? Ask some questions about that if you do. What are the big differences between your proposed worksheet and the opposing parties? Those can be good questions. Is medical insurance for the minor children at issue? Are the division of uncovered medical expenses in dispute? Is the division of the child tax exemptions disputed? If so, all of those things you could ask questions about. Plus, if legal fees and costs are at issue in your case, are the parties' financial resources in dispute? Has the opposing party adopted any unreasonable positions throughout the case? Those are additional things you could ask questions about. For a custody establishment case, what's in dispute for legal decision-making and parenting time? You can ask questions on those issues. Child support, what's the difference between your worksheets? You could ask questions about that. And again, if legal fees are at issue, what are each party's financial resources? Have there been any unreasonable positions? You could ask questions about that. Now, if either side is requesting to modify, if they're requesting to modify spousal maintenance, what are they alleging is the substantial and continuing change in circumstances that justifies the modification? Do you agree or disagree? What questions could you ask about that? Is the amount of the requested modification in dispute? You could ask questions about that. Let's say you're currently paying $250 in spousal maintenance, they want to increase it to $500, but there's no room in your AFI for an additional $250 a month. You could ask questions about that. Have you reviewed my affidavit of financial information? Yes. Did you see that there is not an additional $250 in my budget? Yes. Do you agree that I do not have the financial resources to pay you additional spousal maintenance? So looking at what's in dispute, crafting questions around that. Same thing for legal decision making. What's the substantial continuing change in circumstances? Does it justify modifying legal decision making? What's exactly in dispute? Parenting time. What are the alleged substantial continuing changes in circumstances that they claim justify modifying parenting time? What's in dispute? Child support, same thing. If legal fees are at issue, you can ask questions about that. Now, if you have an enforcement action, questions about the alleged violation, questions about the requested relief, depending on which side you're on. If you're saying the other side created the violation, if that they violated the decree or order, questions proving that. If you're defending against it, questions about why you didn't violate, questions challenging the requested relief. So really crafting your questions based on what's at issue in your case and what's in dispute. Don't forget that you can utilize signposting while you're doing your questions. So here's some examples of signposting. So if you're in a divorce and you want to start asking questions about the marital home. All right, well, now let's talk about the marital home and now start asking your questions. If you want to be even more specific, you could say, now let's talk about your position regarding what should happen with the marital home, and then jump into your question. Next, let's talk about spousal maintenance, or you could be even more specific. Next, let's talk about qualifying for spousal maintenance and get into your questions about qualification. Next, let's talk about your request regarding the amount and duration of spousal maintenance, and then get into those questions. Now let's talk about legal decision making, or more specifically, let's talk about your request for sole legal decision making. Next, let's talk about parenting time, or more specifically, let's talk about your parenting proposal. Let's talk about your request for supervised parenting time. Now let's talk about child support. Let's talk about your gross income. Let's talk about your claim for childcare expenses. This is this concept called signposting. It's not required, you don't have to do it, but this is a very helpful tool so that the judge can follow along with your case. You can organize all of your questions by category, and then as you get into each category, you can introduce it with this signpost. Hey, judge, we're going to talk about legal decision making now. Boom, get into your questions. All right, and just a final review of trial procedure. If you filed the petition and you're going to testify, you're going to be subject to cross-examination by the opposing party. So if you're the opposing party and you're representing yourself, you need to craft some cross-examination questions for the opposing party. All of these parts that are highlighted and in caps, this is the parts that you would need to prepare for if you're testifying, if you're the person that filed the petition or motion. And just to walk through in all practicality, there's going to be opening statements, and then the judge is going to ask the petitioning party to call their first witness to the stand. If you want to be your first witness and you're the petitioning party, you would tell the judge you want to testify. The clerk will put you under oath. You'll start testifying. On direct examination, if you don't have a lawyer, you're going to just start telling your story under oath and incorporating your exhibits, presenting them and seeking to get them admitted into evidence. You're going to be subject to cross-examination. And then once cross-examination is done, you can testify on redirect regarding anything that came up on cross that you want to clarify. If you did not file the petition or motion, then once the party that filed the petition or motion is done presenting their witnesses, the judge is going to turn to you and say, okay, it's time for you to call your first witness. If you want to be your first witness, you tell the judge you want to testify. And that's when you do direct examination. You don't have a lawyer to ask you questions, so you get to just tell your story and present your exhibits. Cross, the opposing party or their attorney will ask you questions on cross. And then once cross is done, you can provide final testimony about things raised in cross-examination that you'd like to clarify or provide additional information about. So if you did not file the petition, you want to prepare cross-examination questions for the opposing party's witnesses. You want to prepare to testify on direct. You want to, prepare to be cross-examined, and then prepare questions on direct for any witnesses you have, and engage in redirect if there's anything that you want to clarify after the cross. So for rebuttal, okay, so the petitioning party presented their witnesses, they rested. The opposing party presented their witnesses, they rested. Now, if there's time and if there's cause to do so, that's when the petitioning party can tell the judge, I would like to testify one more time on a rebuttal, or I have a rebuttal witness to present. And then that's where on direct examination for rebuttal, you would rebut any allegations raised by the opposing party during their case. The rebuttal witness would be subject to cross-examination, and then the rebuttal witness could present testimony on redirect to clarify any points or provide any additional information about things that came up on cross. All right, thank you so much. I hope that was helpful. Cross-examination is definitely an art form. It takes some time to craft the questions and figure it out, but you're definitely a step ahead watching this video instead of just going into the trial or hearing blind. And I definitely wish you the best of luck with cross-examination.